Imagine sitting in a courtroom. The air feels controlled, formal, almost sterile. In front of you sits a defendant, a real person. Across the room, a judge. Around you, other jurors, quiet, attentive, waiting. You've heard the evidence. Some of it feels convincing. Some of it doesn't. There are gaps, small uncertainties. But now the judge leans forward and explains your duty. Apply the law as written. Follow the legal standard. Set aside emotion. Deliver a verdict based strictly on the instructions provided. Everything sounds rational, structured, safe. And yet, somewhere underneath that structure, a question lingers. Are you deciding what's right or simply what's legally correct? In the 1970s, a series of jury simulation studies explored this exact tension. Researchers placed ordinary participants into realistic mock trials. The cases were carefully designed. The evidence remained constant across conditions. The defendant didn't change, the fact didn't shift. What changed was something far subtler, the framing of authority. In some versions, judges emphasized strict adherence to legal rules. Jurors were reminded that their role was not to question the law, but to apply it. In other versions, the instructions highlighted personal moral responsibility, reminding jurors that the outcome rested on their individual judgment. Same case, same evidence, different results. When authority language was firm and directive, conviction rates rose, even when the evidence was ambiguous. When instructions emphasized personal responsibility, jurors hesitated more. They deliberated longer. Doubt resurfaced. Nothing about the facts had changed, only the psychological environment had. And here's where it becomes unsettling. Participants often reported feeling relief when instructions were strict. Clear rules reduced anxiety. Instead of wrestling internally with uncertainty, they could lean on procedure. They could tell themselves, "I'm just applying the standard." That sentence did something powerful. It reduced personal weight. Psychologists call this responsibility diffusion, a mechanism also observed in the Milgram obedience experiment. But in a courtroom, there are no lab coats urging you forward, no visible pressure, just structure, legitimacy, institutional authority. The system didn't force them, it simply made doubt feel unnecessary. There's another layer. When something is labeled legal, the brain often interprets it as right. Legality and morality begin to blur. The language itself carries authority. Beyond reasonable doubt, burden of proof, in accordance with the law. These phrases don't just inform, they stabilize. They reduce psychological discomfort. But history has shown us something critical. Legality and morality are not identical. There have been laws that permitted injustice, laws that defended inequality, laws that later generations would look back on with disbelief. Yet inside these simulations, ordinary people felt safer aligning with the system than with their own uncertainty. That's the key. Human beings are deeply uncomfortable with ambiguity. When outcomes matter, when consequences feel heavy, we crave structure. Authority provides that structure. It narrows the decision space. It offers a script. Follow the rule, trust the process, apply the standard. And slowly, something happens. Internal doubt softens. Group dynamics amplify this effect. In many of these studies, early, confident voices during deliberation influenced the room, not through aggression, but through certainty. When a few jurors spoke decisively, others adjusted, not necessarily because they were convinced, but because isolation feels risky. Disagreement creates tension. Agreement restores balance. Again, no villainy, no cruelty, just psychology. Participants weren't reckless, they weren't malicious, they were responding to powerful cognitive forces. Authority reduces anxiety. Structure reduces ambiguity. Consensus reduces social friction. Put those together in a courtroom setting, and you create an environment where questioning feels heavier than complying.
In post-trial interviews, some participants admitted they paid close attention to tone. If the judge sounded strict, they assumed conviction aligned with expectation. If the instructions sounded reflective, they felt permitted to explore doubt. The human brain is extremely sensitive to signals of expectation, especially in formal hierarchies. And here's the deeper implication. If subtle shifts in wording can influence decisions in controlled simulations, imagine the complexity of real courtrooms, real defendants, real consequences, real power structures. Judges are human, jurors are human, attorneys are human, all susceptible to framing effects, to authority cues, to the quiet relief that comes from believing the system carries the moral weight. The terrifying revelation wasn't that people are evil, it's that people are adaptive. We adapt to structure, we align with legitimacy, we seek cognitive safety when decisions feel overwhelming, and when a system appears orderly and official, resisting it feels almost irrational, even when something inside us hesitates. That hesitation is fragile. Structure can drown it out. So imagine yourself back in that jury chair, evidence spread before you, other jurors nodding confidently, the judge's voice steady and composed, the law clearly defined. Your doubt is quiet, private, slightly uncomfortable. The system feels certain. Would you trust your private hesitation or the authority surrounding you? And if the system assured you it was justified, would you still feel responsible?